Yes, sir. Mr. Chairman, members of the committee, for the record, my name is Ellery Tucker Williams, Legislative and Community Engagement Coordinator with the Idaho Department of Fish and Game. On behalf of the Fish and Game Commission, thank you very much for the opportunity to speak. Idaho's wildlife are recognized by our state constitution and statutes as important public resources of our state, with importance placed on providing continued supplies of public hunting, fishing, and trapping. A recent 2024 Fish and Game policy states that department staff will not enter anyone's home or other living space, barns, shed, other outbuildings, or curtilage unless 1, the owner or resident have consented, 2, there is an immediate public safety threat, or 3, if they are a conservation officer and have a court-issued warrant or are acting under recognized legal exceptions to the warrant requirements. The Commission is concerned that Senate Bill 1326 would significantly limit conservation officers' ability to conduct routine compliance checks and enforce fishing game and trespass laws on private property. This could inadvertently incentivize trespassing and illegal activity, as individuals realize that the risk of being caught on private property is low. This is of particular concern given a 2025 national report by the Boone and Crockett Club titled Reducing the Illegal Take of Wildlife by Investigating the Motivators, Evaluating the Associated Conservation Costs, and Improving Detection Rates of Poaching, that demonstrates that certainty of detection, not penalty severity, is the most effective deterrent for wildlife crimes. Finally, the proposed legislation potentially incentivizes strategic litigation through direct payment of civil penalties to the landowner and reasonable attorney fees in the event that an officer or other entity is found in violation of the conditions of the bill. Fear of being held personally liable may deter or even prevent law enforcement from providing many of the community policing benefits that citizens have come to expect. For these reasons, the Fish and Game Commission does not support Senate Bill 1326. And this concludes my testimony, Mr. Chairman. I'm happy to stand for questions and pull from my bench if I am out of my depth in those questions.
Thank you. Senator Burnt has a question.
Thank you, Mr. Chairman. Ellery, good to see you this morning.
Nice to see you, sir.
Thank you. So give me an example of why a CO would go on a property without a warrant. I get if he has a warrant, that's completely different, but without a warrant.
Ms. Tucker Williams.
Yes, thank you very much, Mr. Chairman, Senator Burnt. I'll provide you a real-life example that my chief of enforcement recently told me. Recently, we had a conservation officer who was driving down a public road and saw, I think it was 3 or 4 people fishing in a creek on private property right behind a no trespassing sign. That individual, that conservation officer, knew that that property had just been sold. So the entity of who that property had been sold to was unknown to the conservation officer. The conservation officer then stopped, ran the license plate of that car that was parked, and found out who the registered owner was, and cross-referenced that with our database on who has hunting and fishing licenses. The registered owner of that vehicle did not have a current fishing license. So one could argue that oftentimes the registered owner of the vehicle is the person that is driving the vehicle. So that individual then went onto that property, contacted those 4 anglers. None of them had fishing licenses. Got their information, was able to then, after the fact, go and took some time, but figure out who the new property owner was, contacted that property owner and said, hey, wanted to let you know I was on your property. I found these people fishing without any fishing licenses. Did they have permission to be there? That landowner then said, no, those individuals did not have my permission to be on that property, and I want you to charge them for trespassing as well. And he thanked the conservation officer for doing that duty. Should this bill have been in place, that conservation officer would have seen that and just probably kept on keeping on.
Senator Shippey.
Thank you, Mr. Chairman. Ms. Tucker, I appreciate you sharing that as a response to Senator Burnt. As I was listening, it really seems like a violation of the Fourth Amendment right. These individuals were presumed guilty, even though they hadn't expressed any guilt. To fish isn't a crime. And for a conservation officer to be able to presume guilt until proven innocent, it seems like a violation of really our protected rights to be secure within ourselves without a warrant or really probable cause. Just because somebody is fishing doesn't show probable cause that they are doing it illegally. So to me, it doesn't convince me that there is prudence in allowing for any officer to presume guilt and so that they would have to prove their innocence, but rather to presume innocence until one is really displayed guilt openly. So I guess that really doesn't convince me. Just because some may be committing a crime or breaking the law doesn't mean that every law-abiding citizen should be subject to search and seizure just because they are out catching fish, hunting, whatever it might be. And so I think we've kind of lost our way a little bit when it comes to the enforcement of the law, in that we now believe it's right to presume guilt. And so then law-abiding citizens have to prove their innocence rather than being able to go about their lives. Does that make sense?
Mr.
If
Tucker
you can
Williams?
respond to that.
Mr. Chairman, Senator, I understand your statements. I'm unsure as to exactly what your question is.
And I don't think there was one. It's just
Okay.
a comment. You're welcome to respond if you'd like.
I will preface that, Mr. Chairman and Senator, with the fact that I am definitely not a lawyer, so I am, again, getting a little bit out of my depth there, but I will say that the individuals were not presumed guilty. It was checking, and to your point, fishing without a license is a crime. So they are not necessarily presumed guilty, but being able to check for compliance, and that is the only way for us to be able to distinguish between those who are and who are not. So for another example is someone shooting regardless of the property, someone shooting a mule deer buck with a license during hunting season looks identical to an individual shooting a buck during deer season without a license. So in order for us to be able to distinguish between the two, given that they are a public resource, and that is the job of the Fish and Game, is to ensure that we have these supplies of wildlife for hunting and fishing and trapping and for continued use in the state, is be able to distinguish between those who are doing it lawfully and those who are not. And our ability to do that is really dependent on being able to check for basic compliance, like licenses, like tags, like weaponry restrictions, all of that.
Do you have a follow-up?
Thank you, Mr. Chairman. Yes, a question on I guess you lined out how the Fish and Game restricts how their officers can approach private property. And I was wondering if maybe you could distinguish the difference here, that what this would actually do and prevent that. I know you gave that example of it would prohibit them from approaching somebody on their own private property, or presumably their own private property in that case, even though it turned out differently. It could have been their own. How that would differ from the Fish and Game's current standards versus how this would limit them, I guess.
Ms. Tucker Williams?
Mr. Chairman, Senator, so I'm going to repeat your question just to make sure I'm understanding it correctly. You're asking for the distinction between what is currently being proposed in the bill versus what our current policy is. Is that essentially your question, sir? Mm-hmm. Perfect. Let me pull it up here real quick for you. And I'm happy to share this with committee. I believe I shared it in my testimony as well that I was submitted to the group as far as a link to our public-facing policy. And just for some background, based off of the feedback that we have gotten, given that this conversation has been going on for several years now, the department did put this policy in place to try and address a lot of these questions. Now, like I said in my opening comments, that it was established in December of 2024. So we are in the process and have been beefing up a lot of our conservation officer training and getting them up to speed on exactly what this policy allows them to do and what it doesn't, because private property relationships and with the Department of Fish and Game are a priority of the department. We cannot do what we do without working with our private property owners. And that's just the pure truth of the matter. So this is an issue that we take very seriously, and that's just why we put this policy together. The main distinction that I see between both our policy and this bill is our ability to do those routine compliance checks. Because again, that is where we are able to make sure that folks are abiding by the current statutes and rules on the books. And so without the ability to do that on private property, it it severely limits our ability to make sure that folks are following the laws of everybody else.
Going to take a question from the pro tem, then we're going to have to move on.
Yes, sir.
Thank you, Mr. Chairman, and thank you, Ms. Tucker-Williams. I'm wondering, in the scenario that you just described, where the anglers were caught, did the officer make an attempt to contact the landowners before he went on the property?
Ms. Tucker-Williams.
Mr. Chairman, Senator, I do know that the individual tried to figure out who the new property owner was, but because it had just changed hands, that information was not available. So after the fact, he was able to put in additional time to figure out whom that new private property owner was and contacted them. If he had not been able to do that, then he would likely have had to leave, put in that time, figure out who those entities, who the new property owner was, and then try to go back to that scene where those folks probably would not have been there.
Follow up?
Mr. We're struggling with a piece of policy here, and what we're trying to balance is property rights versus the enforcement of certain code, right? And in particular, what we're talking about in this particular scenario is the enforcement of, let's say, the obtaining of a fishing license. And so, when we balance that out, and maybe you can help me understand that a little bit better, but when I sit here and I'm looking at this piece of this legislation, and I have to say, what's more important? Mm-hmm. The protection of a fundamental property right, which under the Idaho Constitution and the federal Constitution is fundamental, and whether or not that's more important or less important than the officer's right to enforce a fishing license. It's pretty hard for me to, say it's more important to make sure that officer has the right to enforce a fishing license. Mm-hmm. Help me understand that. Why should I say it's more important for that officer not to have to first contact the property owner before they go right onto that property and enforce the fishing license?
Ms. Tucker-Williams.
Senator, Mr. Chairman, Senator, I appreciate the question, and I understand that this entire conversation is all about balance. And I completely appreciate that conversation. Obviously, being with the Fish and Game Department and representing the commission, it is my job to represent those interests. So that's what I am personally speaking to. I think, speaking more broadly, given that this applies to things outside of Fish and Game, I think there is a lot of conversation to be had about, while we're talking about fishing licenses or we're talking about poaching or whatever that be Fish and Game related, I think there's also a larger conversation about other illegal activities outside of Fish and Game that could also potentially be incentivized, knowing that the possibility of detection is even lower, right? So that could be drug trafficking, that could be stealing cattle, what have you. That conversation is much, in my opinion, much larger than specifically Fish and Game. But that's where our focus is, being that is the commission. As far as why it should matter, referencing back to that national survey that I spoke about in my opening comments, there's an interesting point here that I want to read, if that's okay, very briefly.
We need to get
Yes,
going.
sir. It'll be 2 sentences, if that's okay, Mr. Chairman. Okay. It essentially says that by applying wildlife replacement value of detection estimates, state wildlife agencies and the public, because these are a public resource, lose at least $1.4 billion annually in uncollected fines and replacement costs. On average, each state loses $28.7 million per year. So that is essentially the financial cost to the state of losing our public resources, of us not being able to.
Mr. Chairman.
Sim Pro Tem.
I'll have one more just follow-up if it's okay.
Pro Tem, go ahead.
Thank you. And I'll preface by saying this. I don't care if it costs $3 billion to the state of Idaho if it's going to cost my people their property rights, okay? So let's just start there. Now, we've talked about crime. I've heard testimony today that we've had agents of the government go onto Idaho property owners and swipe elk racks. And the response from the government was, golly, I'm sorry, we'll give them back. But when somebody goes onto a private property and swipes a couple fish, By hell, it's something else. Boy, the government can run right onto private property owner and clobber them in the head. So there's your perspective right there. And I won't, that's not a question, I guess, Mr. Chairman.